don't even think they'll accept him because he doesn't have a drug problem. He just wasn't on his right medication. And his father, I understand his father needs a vacation. He's dealing with 2 adult children, and I don't think he thought his life would be where it is right now, where I'm still having to actively parent. Court is calling 2019 CR 6428, State of Texas versus Anthony Pettis. Can our parties announce for the record for the state?
Marcus Sanders,
Defense,
Jonathan Pettis for Mr. Anthony Pettis.
are you Anthony Pettis?
Yes, Your Honor.
Oh, I remember, this is your cousin. You're talking little cousin. All right, Mr. Pettis, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Anthony R. Pettis who was placed on deferred adjudication in 2019 CR 6428 for the offense of manslaughter on June 29, 2020 for a term of 8 years? Is that you?
Yes, Your Honor.
All right, state.
Condition number 5 in Bear County, Texas, for the defendant Anthony R. Pettis. The defendant there failed to report to the supervision officer as directed on September 21st, 2023. Violation of condition number 5.
How do you plead to that? True or not true?
True.
State.
In Bear County, Texas, the defendant Anthony R. Pettis. The defendant there failed to report to the supervision officer as directed on December 10th, 2021. Violation of condition number 5.
How do you plead to that? True or not true?
True.
Or the other.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violations of conditions 5 and 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violations of 5 and 5?
Yes, Your Honor.
Court will find 5 and 5 true. Is there an agreement?
Judge will deny the motion, altering and order some aftercare, followed by 12 months of ISP. And also no contact with the property on campus. Judge MIRELES.
All right, is that the agreement?
Yes, Judge.
All right, do you understand that to be the agreement?
Yes, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record.
Anthony Robert Perez.
All right, so why are you not reporting?
Can I elaborate?
Yes.
So when we entered into this agreement in June of 2020, one of the conditions, it's not a blatant disregard for the conditions of probation. I believe that there's been a long history of mental health concerns, Judge.
Yes.
And I think what you had ordered back in 2020 was that he stayed current and seeing is that he stays current and seeing this. He's accompanied today by his mother and father. They're here.
Okay.
So most of this is having to do with getting on the right medication and somewhat with the mental illness aspect of this. It's not a blatant disregard for the conditions of probation by the court, Judge. There was a period of time where when he was placed on probation, that he was doing really well, and he had been continuing to go to the facility, and they altered some of his meds. The family's here today, and they're in agreement also that they want him to try and, in safety to get on track. There's some issues in the MTR itself, where there's some admissions that he's making regarding substances, which if you look at the same times for those dates, it's not even true. There are some positives, but most of them are negative. So it leads us to his own the own weight of his own credibility for what he's saying. And that goes in regards to the medication that he's on. And it's my understanding that he was switched on his meds, and there was a shot that was given to him, and it kind of threw him out of whack, Judge. And so this is a mental health concern and a medication concern.
All right. Does his parents want to come up?
Yes, if I can
Yes.
bring his father up, he can elaborate
Yes.
further.
All right, if you could stand to that direction. Hello, can you raise your right hand for me, please?
Ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Could you state your name for the record?
Anthony Pettis.
All right. So this is what the court's concerned with regards to motions to revoke, or anytime I set conditions, I want to make sure that they're the right conditions. So the attorney is telling me that there is some different issue, that this may not be a drug use issue. It may be a prescribed medication issue. So has that been addressed? And if so, how?
Yes, ma'am. They changed his, I've taken him to all his appointments. They changed his medication, or he was climbing the wall. And I had to call every morning to take him to go UA, also get the patch. And a lot of times I couldn't run him through the building. He'd be out there in the front just screaming and hollering at all the cars, just me chasing him everywhere just to try to keep him out of trouble until they put him back on the meds he's on now. They wanted to try something, but that was like a 2-month period. By the time they give him the injection, then they gave him the injection again, those monthly injections, he's just climbing the walls. And that incident that he had at the school, he knows better than to be outside in the front, but he was up before I got up, and he's hollering something like, there's a serial killer inside the school, just scaring all the parents and everything. And that's right across from Andy Mireles. And I knew Andy Mireles. He was a respectable, he was a really good judge. And so when he gets out, he's not going to be living at Corsicana Mill. He won't be living close to a school. And when that happened at the school, I knew the state needed to do something, because they have to protect the children there. And if not, then everybody answers to, including the 187th and everyone. But I took him to all his appointments, and when I couldn't run him through there, I would go in there and I'd tell him, look, he showed up, but he's put on there that he's incapable of going through the line. And then I would take him from there straight to the probation office, because he's all out of his mind, and the doctor's there and everything. And they're really good people over there. They tried to help me the best they could, but they told me, hey, the best thing for him right now, because he hasn't had the chance of an inpatient facility where he can be for a while. So he can get leveled out, but also it'll get him away from the school. And I agree to that. I think there's a 9-month program or a 4-month or what have you, but the longer, the better. So maybe he can learn, because he was smoking cigarettes like crazy, like 15, 20 cigars a day. And now he ain't smoking at all. And those doctors would tell me that when they're smoking like that medicine won't attach to the receptors. It needs to attach in the mind. It's attaching all through the body. So, I don't like him in jail, but when I talk to him, he says, hey, Dad, can I stay here? Anybody in jail's crying to get out, crying to everybody. But him, he seems to be doing all right. And maybe him being separated and learning something, I accept my responsibility. I could be the problem for an enabler, because I've been taking care of him since he was a kid. But every day I got to do something. My life revolves around them. I can't even go get a job. I have to work from home. I need a life, just like he needs a life, and he needs to learn something. The only bad thing is I got another son that's out of control, that brought drugs into the house and all that stuff. I adopted him, and our family doesn't do drugs, and it's just been chaos. And right now he's running around threatening everybody. He's over there supposed to go to the 144th for family violence, and
Related to this one.
Yeah, okay. That's
Yeah,
okay.
well,
No, I'm trying to see. Sometimes people need to communicate to
I'm
vent.
I'm going through a tough time, but I don't give up on my children.
Yeah.
And
It sounds like you need a vacation, though.
I do need a vacation.
Yeah.
I do need a vacation, but my other son, I can't have both of them in the Bexar County Jail at the same time, because my other son's got charges here and also in Atascosa, threatening to kill us and all this stuff. We almost had a knife fight the other day right in front of the house, and the cops show up. It was bad. He had some guy pull up to the front with a gun behind the door, and I ran him off the deck of him. It's crazy, but I can't have both of them in Bexar County at the same time.
Okay.
So if you do rule, Your Honor, please, with all due respect, maybe they can ship them, the sooner the better.
Okay.
Thank you, Your Honor.
All right. Thank you so much. All right. So probation, with regards to his case, is SafeP the appropriate place, or is there, I know because he has the mental health issues and he's medicated, there's some issues with that. So, I mean, it sounds like, I don't know if they'll accept him, but it sounds like the better placement for him would be ISF cognitive and ISF maybe substantive, but I don't know if cognitive will accept him. Will they accept him if he's on his meds?
provide.
Well, they just said that the injections are not good for him. So what about DDRF?
PDR.
Oh, well, we can't do that. So see, people, this is, now let me vent. I don't appreciate the fact that people who need help with mental health have to wait in custody for 42 weeks just to go to get treatment. And I know that's not your fault. I'm just venting. Hopefully somebody in the legislature will hear. Like, yes, I know the Bear County Jail should not be a place to address mental health issues. But from everything I'm listening to, it doesn't seem like his issue is a safety issue, like he has a drug problem. His issue is he has a mental health issue. They changed his medications. And I guess because people are not wealthy, they couldn't readjust his medications immediately. I mean, if he were wealthy, he could go to a place and say, okay, I'm here till I get, leveled out on my medications. But I want something other than safe, because honestly, I don't even think they'll accept him because he doesn't have a drug problem. He just wasn't on his right medication. And his father, I understand his father needs a vacation. He's dealing with 2 adult children. And I don't think he thought his life would be where it is right now, where I'm still having to actively parent.
One other agency, it's a residential.
Yeah. All right, let's, what we're gonna do then, I'm gonna see if Lifetime Recovery will accept you. We'll do Lifetime Recovery. I'll order that. He's to remain in custody till transferred to Lifetime Recovery. If for some reason and I'll need you to stay on top of it, which
Yes,
I
of
know you
course.
will.
Thank you.
If some reason Lifetime Recovery doesn't accept you, we'll bring you back at the beginning of January and see what we can do. But I just don't think Safe P is appropriate placement.
Judge, it was a thing where he was doing so fine. I guess they tried to, hey, this shot or injections will work better. And it just completely didn't.
Yeah. So what we're going to do is we're going to call you back for January 9th. And we'll see if Lifetime Recovery is able to accept you. If they're not able to accept you, if there's no objection,
No objection.
I'll see if I can call around and make some phone calls to see if there's some other placement or somebody knows of some placement that will be great for him.
I appreciate it, Judge.
All right, you're welcome.
Thank
And you may need a vacation from your dad. Sometimes children need vacations as well. All right, who's here on David Gomez?
I am, Your Honor. We're ready on that.
All right, if you can come forward in probation, this is no application. Court is calling 2022 CR 7971, State of Texas versus David Gomez. If I could have parties announced for the record for the state.
Marcus Sanders.
Arnulfo Ortiz for Mr. Gomez.
Are you Mr. Gomez?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Gomez, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Any objection?
No objection.
Mr. Gomez, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney?
Yes, Your
Did you
Honor.
understand it and did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with theft, 2,500 to 30,000 of a vehicle, counsel? Did you understand that the range of punishment for that offense is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Your Honor.
Mr. Gomez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, ma'am. Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 1 year in the state jail facility. There are no applications. There's to be restitution, if any, to George Taylor and no contact with George Taylor. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
It is, along with credit for time served.
All right, state.
Yes. My hesitation is I initially ordered restitution because he was gonna apply, but since it's an agreed sentence, I guess we would strike through the restitution.
Any
That's
objection?
correct. No objection.
All right, next I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense is charged in the indictment. How do you plead? Guilty, not guilty, or no contest?
Guilty. No contest.
State any evidence?
Yes, state offer states exhibit 1 and attachment.
Any objections?
No objections.
Mr. Gomez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And
Yes,
did
Your
you
Honor.
sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
We are.
Anything you wish to say on behalf of your client?
Your Honor, my client has come to his senses. He understands that the 1 year is a good deal. He apologizes to the court for his behavior. He understands he's getting a little long in the tooth to be doing this kind of thing. That's all.
All right, then the court will follow your agreement. The court will sentence you to 1 year in the state jail facility, give you credit for any time served, and there's to be no contact with George Taylor. Is there anything else from either side with regards to sentencing?
Nothing further, Your Honor.
All right, I'm going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because, I'm sorry, this goes with it too. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you. We can go off the record. How old are you?
I am 32 years old.
I mean, at some point, you can't be doing this anymore. You understand?
Yes, ma'am.
Because otherwise you're going to find yourself in and out of the Bear County Jail or somebody's jail and in and out of prison.
Yes, ma'am.
If you don't want that to be your life, you need to change your ways. So I'm going to give you a crash course of cats 1 and 2. Do not take what doesn't belong to you. I don't care if somebody leaves the keys on their car seat. You know, it's not your vehicle.
Yes,
Don't
ma'am.
take it. All right.
Yes, ma'am.
Okay. Good luck to you.
Thank you. Thank you.
All right. And I'm sorry. What is your name again?
Miriam Padron.
All right. Miriam
Padron.
Butler. All right. On Miriam Butler's case, Ms. Lopez,
Padron, I'm sorry.
I'm sorry.
Padron, I'm sorry.
Okay, Miriam Padron. What I've ordered is she's going to have the portable device. She's going to supply you with an affidavit of non-driving. And she's already given the court a copy of the fact that that vehicle has been sold for parts. But she will supply, her attorney will give that to you as well. So when do you want her to, you're on mute. When do you want her to report to you?
Okay, I would just need to get that that court updated information, then we can go ahead and discuss the next time to report into me. But she does know she's supposed to report in weekly, but as of right now, since we're pending the response of that violation letter we submitted, right now it's on hold on when she's like the next time to go ahead and see what's her next steps for.
Now, they're sending you the violation now. So when do you want her to report?
Once I get it, if I get it within the next hour, I'll contact her today and discuss the next steps to do.
All right, so this is what's going to end up happening. She's going to call you. Yeah, we've already done it. Yes. So this is what's going to end up happening. I want you to call Leslie Lopez today. You have her number?
Yes.
All right, because that violation report and my ruling on it is being sent to her right now.
Okay.
Okay, and she's going to tell you when to report, but you need to get that portable monitor.
Yes.
Okay. All right, is there anything else?
No.
All right, thank you.
Thank you.
Thank you.
Thank you.
Brian Michael Flory. And probation, this is no application. Court is calling 2022 CR 8419, State of Texas versus Brian Flory. Could I have parties announced for the record for the state? Defense? And are you Mr. Flory?
Correct, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, and I did.
Court will find that the state is in compliance with discovery. Mr. Flory, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, waiving count one and the enhancement paragraph.
Any objection?
No, Your Honor.
All right, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes, ma'am, that's correct.
Did you understand in count two, you're charged with the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams as a second degree felony? The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Correct.
That's either yes or no.
Yes, ma'am.
All right. If you have a plea bargain agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Flory, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. All right, everyone, just give me one moment. I'm trying to see something here. Back on the record in 2022 CR 8419. All right, we're back on the record. Are there any motions from the state?
Yes, Judge, we'd like to urge the four motions in the indictment to change the offense date from October 19th, 2020 to August 19th of 2020. In count two.
All right, is there any objection?
No objection. I've consulted with Mr. Flory.
All right, Mr. Flory, do you understand that is a substantive change to the indictment?
Yes, ma'am.
And knowing that, do you still wish to proceed with your plea bargain agreement with that change?
Yes, ma'am.
And do you understand that your attorney has 10 days to prepare for trial with that substantive change?
Correct.
And knowing that, do you still wish to continue?
Yes, ma'am.
Okay. All right, then the court will grant the oral motion. All right, I'm going to show you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
All right, according to the plea, just one second, let me see where we're left off right now. My mind is a steel trap, but not today. That's okay. It's Friday. I'm trying to get people. All right, thank you. All right, so I'm going to show you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count two. They're asking that your punishment be assessed at 2 years in the prison, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, sir.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it, and did you sign it in both places?
Yes, ma'am, Your Honor.
You understand by signing that you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Your Honor.
Then to the offense in count two, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
If they offer states exhibit one.
No objection.
All right, I'm showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states one in attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right, the court is finding you guilty, sentence you to 2 years in the prison and give you credit for any time served. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am, Your Honor.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So from reading police reports, I see that you have a girlfriend. I don't know if she has children or not, but do not bring this to her doorstep. You understand?
Mhm.
And if she has children, do not bring that to her doorstep when she has children. It's easy for adults to do foolish things, but children have no choice but to be involved with it because you're making them be involved.
Yes, ma'am.
So be a good human being. If not for yourself, be a good human being for children and people that you're involved with. Okay.
Yes, ma'am.
All right. Good luck to you. Thank you.
Judge.
All right. So who's here on Omar Kalanga?
Charles and I are here, Judge. I think we're ready.
All right. If they'll come forward.
Okay. Omar.
I'll get her. Court is calling 2022 CR 4752, State of Texas versus Omar Kalanga. Could I have parties announced for the record for the state
Brittany Sparks.
defense?
Charles Buck from Mr. Kalanga.
And are you Mr. Kalanga?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case? And did you review it with your client?
I have and we did.
Court will find that the state is in compliance with discovery. Mr. Kalanga, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Judge, we're proceeding only on count 1. We're going to waive count 2 as well as the enhancement paragraphs.
Any objection?
No objections.
Mr. Kalanga, I'm showing you what's entitled Court Admonishment and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Absolutely.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and is legally sane at the time of the offense?
Yes.
Mr. Kalanga, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 8 years in the prison. There's an affirmative finding of deadly weapon. There are no applications. This is to run concurrent with the Cameron County Cause number 2012 DCR 1795. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Yes, Judge.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Judge.
Then to the offense of, and count one, how do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State any evidence
Yes, Judge stated, offer states exhibit one, all I have.
No objections.
showing you what's entitled a waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
We believe he's worthy of the plea bargain. We ask you to follow it.
All right, the court will sentence you to 8 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. This will run concurrent with Cameron County case 2012 DCR 1795. And there's to be no contact with Jason Harmel, Harmel. Next, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record.
Judge, the only thing on the ball, we're still on the record. He's
On the
been in
record?
continuous, yes, please. He's been in continuous custody since July 23rd of 2021. Some of that time was out of county, but I've given the clerk of your court paperwork, the documentation. I'd ask that the record reflect his credit begins on July 23rd of 2021.
All right, any objection, state?
No, Judge.
All right, it will reflect.
Okay, thank you.
All right. You need to do better. You understand? Otherwise, you're going to find yourself in and out of prisons and you're going to look up and a majority of your life is going to be spent in prison. You understand?
Yes, ma'am.
All right. Good luck to you.
Where were you late?
Riding the bus. I don't really know how to ride the bus like that. So
I was into the ride bus like that. You find out what the route is and you get up early.
yeah, I'm no excuses, but I never like rode the bus like that. I've always either drove or had a
I rode
ride.
the bus. And this is the second time you've been late.
I know, I'm sorry.
Well, no, here's the thing. At some point, your sorry is not gonna get us. So if you want, I can have you ride the bus, but the bus that you'll be riding will be the one that the inmates ride, and we'll make sure that you're on time. And you can figure out how the inmate bus works. Do you want that to happen?
No,
I've ridden the bus before. There's nothing wrong with riding the bus. And I rode the bus when I was a defense attorney, and you know what I would do? I would end up at court at 7:30 a.m. Do you know why? Because I knew I had to be in court at 9, and I knew that things could happen with riding the bus. Because sometimes the bus runs late, and guess what? Sometimes the bus runs ahead of schedule. And when it runs ahead of schedule, they don't wait. They're really supposed to stay there and wait till it's on schedule, but they don't. And when your bus is late, guess what? The next transfer that you're supposed to take, it would already be gone and you would have to wait. So for me to be on time in court, I would usually end up getting here at 7:30, 7:45. Which bus did you take?
I got on the bus. I know bus 8 brought me down here. What bus I got on?
You should know your routes. I still know my bus route. It was
Because I got on from Raybon. From the Spring Hill Apartments.
So here's the
But I know 8 brought me down here to the courthouse. And I got off a block away. So it was a block because I've asked the bus driver where I go from there. He said, go up a block and over a block. And that's what I did. And that's how I
So I would ride the bus all the time, so that's not an excuse. So I'm not gonna tolerate you being late again.
Okay.
And if you're riding the bus, then you need to pre-plan your schedule.
Okay.
And I would tell you this, if you're leaving from here and going back home, the fastest bus you can get on is number 90, because that's the express.
I'm here to Raybon.
92 will take you the entire length of Fredericksburg, and that's how I learned San Antonio. Because I would get on the 92 and Fredericksburg Road, basically transfers San Antonio. And if you get on the looper, which is the 550 or 551, it's gonna take you a loop around the city, and if you make a mistake and get on that bus, that's gonna add some time to your ride.
Okay.
So you had better, if you're taking the bus, you had better start navigating how you get there.
Okay.
And if it's the first time taking the bus, when I tell my mom I was taking the bus, the first time, you know what she said? Just ask the bus driver, they know. You can tell them, hey, this is where I am. What is the quickest route? And not only would they give you a sheet of paper that shows you the bus route, they'll mark it off to tell you, this is the quickest route for you to get where you need to be. You gotta ask questions.
Okay.
The first time I rode the bus here, I didn't realize you had to pay. Because in Baton Rouge, you don't. No, in Baton Rouge, you don't have to pay for the bus. When you're in school, just get on the bus and it takes you wherever you want to go. You don't have to pay for it. So the first time I got on the bus here, I actually had to pay. I was like, this is nuts. Why are you guys paying for a bus? I'm a student. So what are we doing with your client's case?
We need a trial setting, Judge.
All right, have you received an offer?
Yes.
And when did you receive the offer?
Well, some time ago, it's marked there. So last setting,
Like 2 weeks ago.
And are you rejecting that offer?
Yes.
All right, Ms. Ferguson, I need a jury trial date. Is this family violence or criminal trial division?
criminal trial division.
All right, criminal trial, how long do you expect this trial to last?
Natasha Jenkins.
Judge,
It's an aggravated assault with deadly weapon.
2 or 3 days.
Judge, I don't know any of the facts, but I wouldn't imagine longer than a week.
All right, Ms. Ferguson, I need a jury trial date for Jenkins. January 24th. All right, we're gonna come back on January 24th. We will be on time. If you're not
Yes,
on
ma'am.
time, we're probably gonna have to make sure that you're on time.
Yes,
By giving
ma'am.
you transportation from the jail bus.
Yes, ma'am.
Ms. Ferguson will give you a reset form.
Court is going to call 2022 CR 0272, State of Texas versus Aaron Schramm. Could I have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Arlene Gay.
And are you Ms. Schramm? You need to unmute.
Yes, ma'am.
All right, Ms. Schramm is by video. Any objection from the state
No, Your Honor.
defense?
No, Your Honor.
All right, and Ms. Schramm, where exactly are you located?
Medina, Texas.
All right, we're here for sentencing according to the plea bargaining agreement. Punishment is to be assessed at $1,000 fine probated, and the state is recommending deferred adjudication. Are both parties ready to proceed?
Yes, Your Honor. Yes, Your Honor.
And I don't believe because this is an agreement, I don't believe a PSI was done. Is that correct?
That is correct, Your Honor. Both parties anticipated it being waived. I know, Michelle, you weren't the prosecutor, but the folks I was dealing with, we all anticipated it, but due to unforeseen issues in impact court, we're just coming up here presenting.
All right, counsel, the court was given a copy of the victim impact statement. Have you had a chance to review that?
Yes, I have. I've actually been provided a copy of it.
All right, do you have any objections to the court reviewing that and taking that in consideration?
I have no objections, Your Honor.
All right, is there anything, state, do you have any witnesses?
No, Your Honor.
Defense, any witnesses?
No, Your Honor. Just by way of argument, whenever the court's ready.
All right, and who did this plea? Which
Judge Angelini.
Okay.
She entered her plea of no contest, and we were anticipating, like I said, to be sentenced to deferred.
All right, Ms. Strom, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. I'm gonna need you to keep your voice up. Could you state your name for the record?
Aaron Sturm.
All right, I see that there is supposed to be contact through app close. I'm assuming that you and the complainant share children?
Yes, we do.
All right, how many children do you have?
One son. He's almost 4.
And are you employed?
Yes, ma'am.
And what do you do?
I'm a housekeeper
And how often are you doing that?
daily.
All right, and what's the location?
It's around Medina and Bandera. It's local.
All right, are there any drug or alcohol issues?
No, ma'am.
I see that there is a family law case.
Your Honor, I was the attorney on the protective order for Ms. Strum and Benton Benton Leachman, excuse me.
Mhm.
He was for the state. What we did, and the family code allows us to make family law orders in the protective order.
Yes.
So we have visitation, and her visitation, because our case was pending, is supervised. I have a copy of the protective order, but I just don't have one signed by the judge. We all signed it. I've been trial and I just couldn't get the signed one, but it's in effect, and she has a copy of it. Wherein her mother is the supervisor of her. And this was done because the case was pending. If they choose to change that, they can, like any family law order in the future. But she's to use the family law app and have visitation with her son on and what we call a standard visitation, as the court is aware of what that is. So that's already in place, and until it's changed by a family law judge, we anticipate that a divorce will be filed by my client. Neither party has filed, and I think this has just been trying to get past this case. And but my client anticipates filing that divorce, and that's why we put in there other orders that may be entered by the family law judge or family law court, because we anticipate that there will be orders in the future, and it may be within the 2-year deferred period. So we wanted to make sure that a judge will know about what you're doing, Your Honor, and that there's consistency, and we don't have to come back for future orders. But right now, there's no physical contact between them.
All right, so what the court has is, according to the plea bargain page, it had a deadly conduct in the plea that you all were proceeding on that, but then it's crossed through. But the plea paperwork said deadly conduct. Is there a reason that's been crossed through? Because I just want the record to be clear. So do both parties agree that the plea bargain was for a reduction to deadly conduct as a Class A misdemeanor?
Yes, Your Honor. I don't know whose marking that is.
Not mine.
And I don't draw straight lines, Your Honor.
Okay.
But it was, in agreement with the reduction. Yes, Your Honor. I don't know how that ended up that way.
Okay. So, Ms. Sturm, you're understanding that the plea you made was for a Class A misdemeanor of deadly conduct. Are you aware of that?
Yeah.
All right. And state, I'm assuming, is this an affirmative finding of family violence also?
No, Your Honor.
No. State?
Judge, I don't see anything in the agreement indicating that we were including that.
No.
All right.
Well, does the court want the state to write deadly conduct above deadly conduct that's marked through? I only have a red pen today.
That's fine.
Okay.
That should probably be best.
Yes.
So there's no issue with regards to that. All right. And is there a reason why there was not an agreement for affirmative finding of family violence?
Your Honor, that was part of the plea bargain. This was a case that we're planning to take to trial. We believe that we had a strong case, but in wanting to resolve the case and not wanting to go to trial on an aggravated assault of deadly weapon, we entered this plea bargain. Actually, it was entered between me and Michael Villarreal. And that was part of the plea bargain.
And Judge, I just confirmed that was the state's position as well.
Okay. All right. This is what the court is going to do. 2 years deferred adjudication. There's $1,000 fine to be probated. Take in consideration County Court Cause number 664231. The court is going to order parenting classes. There's 48 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. The remaining hours will be waived if you provide proof of the parenting classes, and if she's already done that on the family violence, she can just give them documentation of that.
She has done one months ago. But she informed me of, I haven't gotten it yet, Your Honor, but make sure probation gets it.
All right, there's to be no in-person contact with Joshua Morrison. Contact is allowed through the closed app only. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be regular reporting by Zoom or in person. I'm assuming transfer to Medina, but Bear County services Medina, is that correct? All right, so we'll do a transfer to Medina County. I'm going to want field visits 1 time per month until further notice. You can do regular UAs or you can do the patch. Your attorney will explain to you the difference. Basically, patch is more expensive, but with the patch, there's less time constraints on you because they put it on and they tell you when you need to show up to have it removed. All right. Probation, is there anything else she needs? All right. And we'll do an anger management course. Ms. Sturm, is there anything else you need from the court?
No, ma'am, I don't believe so.
All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did
Yes,
you
ma'am.
sign it?
Yes, ma'am.
Because this is a plea bargaining case, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Is there anything else from either side?
No, Your Honor. No, Your Honor. I'm just filling out that other dismissal right now.
All right, Ms. Sturm, I'm going to need you to stay on. I'm going to send you to a breakout room with probation. They'll go over conditions with you.
Okay, yes, ma'am.
All right, we can go off the record. Ms. Sturm, I
Yes,
don't
ma'am.
know what the situation is between you and the father of your child, but what I can tell you is children don't need this upheaval in their life. You understand? So
Yes, ma'am.
everybody is going to have to start communicating with kindness and respect. Whether you respect the other person or not, that person is the father of your child. And if you're able to treat each other with respect and kindness, even if you're faking it, one day it will come from a place of true kindness and true respect, because a child does not need to see their parents being this way. You understand?
Yes, ma'am.
All right, I'm going to send you all to a breakout room, and probation will go over conditions with you.
Okay.
Counsel, do you need to be there as well or no?
No, I don't believe so, Your Honor.
All right, thank you. Then you are excused.